Welcome to Wales Tech Week 2021. Thank you to our partners. Enjoy the session.
Hello everyone, and thank you for joining me on the pillar stage today for this webinar. My name is Elliott Davies. I'm a patent attorney at Wynne-Jones IP, which is a legal company that specializes in protecting the intellectual property assets of individuals and companies. Intellectual property typically arises from research, development, activities, testing and the like, and with all the effort and time and money that goes into R&D, it's important to protect your work products by securing the relevant intellectual property rights. Now, in my experience, however, this is not always the case, and I often come across individuals and companies who find that their work has been copied and exploited by third parties. So as you can imagine, this can be quite frustrating, demoralizing, and often upsetting. So today, I'd like to just run through some of the things to consider when developing new products and processes to ensure that you capture the relevant intellectual property rights, and also some of the benefits which can arise from owning intellectual property rights. If you have any questions, then please pop them in the comment section on the right of your screen, and I'll try and pick them up as I go. If not, then I'll try and pick them up at the end. So let's first consider a hypothetical journey of taking a product from a concept to a commercial offering. Let's assume your concept relates to a vacuuming machine. So here we have a hypothetical timeline showing the development of the machine. We have the initial prototype, an early version, a Mark I version. Then we have what you may think of as a minimal viable product, your initial commercial product. And then over a period of time, you'll probably make further developments and launch the deluxe version, and then your latest advancement being the super deluxe, the autonomous vacuum cleaner shown on the top right. Now, in order to protect your vacuuming machine, or machines in this case, you should consider the full suite of the various intellectual property rights. And they include the patents, trademarks, designs, copyright, and trade secrets. However, it can be difficult to determine the rights which are applicable to your machine, and indeed when to secure them. Also, it's not the case that a product or service will only exclusively attract one type of intellectual property right. There are a number of rights, and each right will serve to protect a different type of development. For example, the patents protect the underlying technical concept, the function or operation of the vacuum machine, for example. Then the designs, on the other hand, are used to protect the aesthetic appearance or the look of the product. Then you have trademarks, which protect the particular trade-in name of the product or indeed your company. And there's also copyright, which is used to protect things like brochures, manuals, the web content, and source code. So you can see that a single product will typically attract a number of different intellectual property rights. And when developing a new product or service, it's often also necessary to commission third parties to perform certain activities. And when doing so, you should ensure that you retain ownership to the IP rights arising out of that commission. For example, if you were to commission a third party to write code for a control module of your autonomous vacuum machine, then that third party would typically own the copyright in that code. You need to be sure that all the rights which arise from a collaboration or a partnership are assigned to you or your company. Now, IP rights which arise during the course of an employee's employment typically pass to the employer, but nonetheless, it's useful to have specific IP provisions in place in their contract also. Now, when it comes to the branding, before you consider using a particular mark, let alone filing a trademark application to register the mark, you should first consider whether you are free to use that mark. Are there any third parties, for example, which operate in a similar field to you, which use the same or similar mark. So we recommend conducting a search to assess your so-called freedom to use the mark. This can be quite important because it can be costly to rebrand several years down the line. And more importantly, if you do have to rebrand, then you'll have to spend additional time and effort rebuilding the reputation and goodwill under a different name. So similarly with patents, are you free to commercialize the technology? Do any of your competitors hold patents which prevent you from making or selling your products? So again, you should consider a so-called freedom to operate search, whereby relevant patents are identified. This is an important point because having the patent yourself doesn't entitle you to commercialize the invention. It only entitles you to stop someone else commercializing the invention. So in addition to patents, designs, and trademarks, which require a public disclosure of information as part of that application process, if instead you wish to capitalize on particular know-how, then you should also consider the intellectual property right known as the trade secret. So if you have any proprietary information which you would prefer was kept secret, then you should take steps to safeguard that information. For example, is the information held on a public file space? Do you have permissions in place for personnel to access that information? So you should ensure that you have various measures in place to keep the information secret and limit the access to that information. Trade secrets are or can be much less expensive to obtain and maintain than other IP rights, but you will need to put measures in place to keep that information secret. Now, there is a cost to obtaining and maintaining certain intellectual property rights, so you should set an appropriate budget as part of your R&D. This is important. You will need a budget. It doesn't need to be large, but it does need to be realistic, particularly in view of your markets. And the budget for IP needs to be set just like any other department of your company. So you have assigned funds ready to support your IP strategy. Now, when it comes to the budget will depend on the type of rights you require, and so will depend on your service or product offering. Patents are generally more expensive than other types of IP rights, and the costs are spread out over a longer period. So it can be useful to obtain cost forecasts for these rights to help you set your budget. So you should consider those territories you require protection and budget to protect the product in at least your main markets. So you can see that when developing a new product or service, there's quite a bit to think about. But essentially, all you need is an IP strategy. If you do not have an IP strategy, then you run the risk of scuppering the protection of your assets. So it's important to identify your core products, identify the best rights to protect the products, ensure that you maintain ownership in any rights derived from collaborations or partnerships, and consider your freedom to sell and market your products. Now, when taking a concept through to a commercial product, there is often an urgency or some time or financial restraint and a general desire to tell people about your product. So understandably, people are keen to promote and market their product, if it's only just to generate some form of income. But they're also quite keen to show their latest advance. However, these factors can contribute to a disclosure which can jeopardize your intellectual property rights and indeed your business. So let's look at some of the problems which can occur as a result of these prior disclosures, if you like. So as mentioned previously, it can be difficult to know when to secure various rights. But generally, it's best to secure intellectual property rights as soon as possible, since anything made public prior to filing an application for a patent or a design, for example, can be used to challenge the validity of that right. This includes any prior disclosure of a concept made by you or your employees, for example. Now, different rights have different consequences for prior disclosure. Now, when it comes to patents, you should ensure that all new concepts are kept secret until a decision is made whether to file a patent application. That obviously raises a problem when you need to consult with third parties in developing the product. So in these situations, you should ensure that your consultants or other parties execute clear non-disclosure agreements. This type of agreement enables you to disclose information without destroying the novelty in the concept. They are not ideal though, because in the event that a third party does disclose information, then all you have is effectively a breach of agreement. And it may not be possible at that stage then to subsequently file a patent application. So it's always advisable to file a patent as soon as you have sufficient information to hand. So when should you file a patent application for this vacuum cleaning machine? Well, looking at this slide, once you have an understanding about how the invention can be realized, how it can work, then you should consider filing a patent application. In this case, you should consider filing at the time indicated by arrow A, so just after you have developed your working prototype, for example. Although I would say you don't need a working prototype to file a patent application, but you do need to know how the device will work. If you were to wait until you have demonstrated the product at an exhibition, for example, such as waiting until time B, then your patent application will most likely be invalid because you would have disclosed it before you filed the patent application. If, though, after filing an application, you then make changes to the product, such as with your modified version, then you should consider capturing those changes in another patent application or even the same application before you disclose them. So in this case, you should consider filing a patent application once the modifications have been made, such as at time C, which is before the first sale. Now, in the case of design applications, the consequences of prior disclosure are not as severe as with patents. It's possible for a designer to disclose details of the design up to 12 months before the application is filed. So in the examples shown, it may be possible to protect the look of the commercial product even after it's been placed on sale. With trademarks, it's possible to use a particular mark and then subsequently file a trademark application. There's no actual penalty for disclosing the mark before you file the application. However, I would say in all cases, it is important to note that the first party to file an application to register a patent or a design or a trademark will be the legal owner. And that's because in the UK, we operate on a first to file basis. So even though it may be possible to show a design or use a trademark before filing the appropriate application, if a third party was to file a design or a trademark themselves for the same thing, then they would get prior rights to that design or trademark. So that's why we recommend filing the respective application as soon as possible. So when should you consider intellectual property rights and how do you identify them? How do you harvest these rights for your benefit? So referring again to the development of our vacuuming machine, you should introduce regular steps in the development cycle of the product, as shown by the red arrows. This is to ensure that the developments and modifications are captured and assessed. So when it comes to identifying potential patent applications, for example, you should ask yourself, have you had to overcome any technical problems? And if the answer is yes, then the solution may warrant patent protection. So these stages will also help your employees harvest potentially inventive concepts and hopefully avoid any disclosures from taking place, so that you can make an assessment about whether to protect the concept. It may be the case that some information may be simply just best kept secret, such as, for example, a particular set of operating conditions which provide for an optimal operation of the machine. So having these harvesting stages in the development cycle will help capture the important aspects so that they can be documented and appropriately actioned. Now, with designs, it's generally best to wait until the look of your product has been finalized. This is because when you file a design application, it's necessary to submit drawings of the design in question. So the protection is limited to the images shown in the drawings. So you want to be sure that the protection is directed to your commercial embodiment, to the actual design of or look of the product that you're selling. Just to mention in passing, sometimes it is possible to file patent and design applications roughly at the same time, but you should note that design applications are published quickly by the UK Intellectual Property Office. So if you intend filing a patent application for a concept, then it's advisable to file the patent application first to avoid any potential issues that may arise if the design application is published before the patent application is filed. As mentioned, trademarks, it's possible to file an application after the mark has been used, but just like patents and designs, trademarks should be filed as soon as possible so that you can secure the rights. Now, before committing to the expense of a patent application, it can be useful to assess whether a concept is already known. It's useful to assess whether it's patentable, for example. Another important aspect to consider is the activity of your competitors. And this can be done by carrying out searches and performing an analysis of the data and the statistics. This is known as the analytics. So analytics allows you to understand the technical landscape you are operating in, and it enables you to gain some valuable intelligence on your competitors. The analytics can also unlock some insights to help you plan and create strategies for your rights and your research and development. So patent analytics is much more than just an IP tool. It's a business critical service, and there are 4 types of searches which you can undertake to obtain this information, and they include the watching and monitoring search, the patentability search, the freedom to operate or FTO, which is also known as the infringement search, and then you have the invalidity search. So let's look at these in a bit more detail. A watching and monitoring search is used to keep a track on the activity of various companies, for example, by monitoring for newly filed patent and trademark applications. Knowledge of this activity can help reveal information about a company, and it can also enable you to take early action to challenge and prevent a patent or trademark application that's been filed by a competitor from proceeding to grant. You can take steps early on in that application process. So for example, suppose that a monitoring search revealed that some company filed a patent application for a new product. This may give some insight into whether that company is looking to diversify into a new product range or make a new service offering, or whether your R&D may result in a product which could infringe the rights of any patent granted to that company. So once you're armed with prior knowledge, this can help you make the commercial decisions about the direction of your R&D, for example. Now, most people would have heard of the phrase patent search. However, many people incorrectly assume that a patent search would provide some indication about whether a particular product may be patentable, and also whether they would be infringing any patents if they were to commercialize their product. Now, that's 2 sides effectively of the same coin. So, and it's important to distinguish between 2 completely separate patent searches. So we have on the one side, we have the patentability search, and on the other hand, the other side, we have the freedom to operate search. Now, a patentability search focuses only on whether your product or device may be patentable. And to be patentable, your concept must never have been disclosed anywhere in the world prior to the filing date of your patent application. So a patentability search is not limited to only searching for patents. It can include a search for anything that's published, including magazine articles, lectures, videos, web disclosures, and even prior use. So anything which has been published anywhere in the world prior to the filing date of your patent application can be used to challenge the validity of the concept, the validity of the application. And so A search that can draw on any resource to provide you with information about that state of the relevant art can be a useful indicator as to whether your concept is patentable. However, generally, a patentability search will principally scour patent databases. I think that's largely because it's much more searchable for relevant data. And some of these publicly available databases are shown on the screen there, such as Google Patents and PatentScope. So PatentScope is administered by the World Intellectual Property Office. However, the most common and probably most useful is Espacenet, which is a database of published patent applications that's administered by the European Patent Office. It's possible to search this database using keywords or names, for example, names of applicants or companies, even names of inventors. And this can be a useful starting point to see whether your concept's already known. However, just to point out that with the Espacenet, the search is typically performed using keywords, and keyword searching can be a little hit and miss at times. That's because it's dependent on the keywords which are used to seed the search. We can conduct more exhaustive searching using technical classifications, and this type of search can give you more confidence in the search results. Nevertheless, keyword searching can give you a useful indication. With patents, you should also note, though, that applications are only published 18 months after they are filed. So a search through a patent database may not always retrieve all patents because some of those may not yet have been published. And this 18-month period is particularly important when it comes to infringement. So we just discussed a search to assess whether a concept is patentable, the patentability search. On the other side, we have whether your concept, if commercialized, would infringe somebody else's patent. And if you are more concerned about whether your product infringes the rights of a third party, then it's necessary to perform this type of search. If you cannot commercialize your product as planned, for example, then that's a problem. You may need to rethink your R&D and maybe steer your product in a particular way to avoid infringement. So an FTO search can help identify problematic patents. It's restricted to patents which relate to your product. So it's focused only on patents which relate or fall within your technical sector. And it's related only to those patents which are active in the territories in which you intend to commercialize the product. That's important because even though there may be a patent in the US, if you're not selling a product in the US, then there's no risk of infringement. Also, as patents have a maximum life of only 20 years, then you only need to search for patents which have been filed within the last 20 years. If you only intend, like I said, if you only intend commercializing a product also in the UK, then we can restrict and filter the search just to the UK. But like I said, as patents are only published 18 months after filing, it's important to note that it will not be possible to assess the infringement risks of applications which have only recently been filed. So we recommend performing a top-up FTO search 18 months later to try and capture those which have been filed but not yet published at the time of carrying out the original search. So generally, a freedom to operate search should be carried out or considered at least early in the product development phase, since it may be possible to avoid problematic patents that are identified. At that early stage, it can be a lot more straightforward to modify the product, tweak it slightly to remove some technical components or include technical components to avoid or to redefine and redevelop the product to avoid an infringement. It can be more costly to do that once you're nearing the product launch phase. However, if you do identify problematic patents, then it's also possible to challenge the validity of the patents and possibly invalidate them to effectively clear the way for you to commercialize your products. Now, an invalidity search is similar to a patentability search, but it's restricted to publications made before the filing date of the patent, the problematic patent. And that's because only publications made prior to the filing date can be used to challenge validity. This type of search can be used in conjunction with a monitoring or watching search, so that once you become aware of a possible problematic application, you can take steps to identify subject matter publications which can be used to challenge the application, namely prevent the application progressing to grant. An invalidity search is typically used, or also used, when you've received a letter, a cease and desist type letter, which informs you that you're potentially infringing somebody else's patent. It's a common defense in patent infringement proceedings to claim that the patent is invalid. And so to substantiate that argument, you would need to have some evidence to show that the concept was publicly available, and that's where the invalidity search can come in. So if you have relevant prior art in a patent infringement action, then this can be useful in negotiating your way out of that action. Okay, so having done all that, having carried out various R&D and performed various harvesting stages to capture IP and secure your patents, trademarks, designs, you've performed all your searches and monitoring. Having done all that, show me the money. What's the financial incentive for obtaining and securing intellectual property rights? Well, you will have often see on Dragon's Den that the first question candidates often get asked is, have you secured the rights to a particular product or brand? And this is because without those rights, anyone can capitalize on your hard work in developing and refining your products. So without these rights, you cannot corner a section of the market or command a premium price for your product. Intellectual property rights can provide market exclusivity, which is attractive to investors. It's no surprise then that intellectual property rights are assets. They can add significant value to a company by creating a monopoly. So third parties who want to exploit your works, your rights, would need to take a license, for example, which again can be offered with a premium royalty. So there's a two-pronged attack. They corner the market for you by ring-fencing your technology so that somebody wants the technology, they have to come to you. And if a third party does want to benefit from that technology, then they need to take a license. So as you can see, IP rights are important when looking to raise finance and command a premium price. However, your IP rights are just one aspect of your IP strategy that an investor will consider. So when I say an investor, I don't just mean an investor as in an angel or private equity investor. It could also be some form of grant assistance you're receiving, or if you're looking to raise finance from the bank, because banks these days tend to lend money on the strength of intellectual property rights. So to make an investor happy, because at the end of the day, you are asking them to put a significant sum of money into a venture that has risk as well as potential reward. IP rights can help generate the reward by adding value to the company, but there's also a risk that you cannot commercialize your products, for example. So an investor will also consider your freedom to exploit your technology. So an investor will be looking for an IP strategy that's joined up and coherent with a business strategy. And when pitching for investment, it's important to be clear about your IP rights and your research into your competitors to show how your strategy can benefit the business. So we have recently developed a number of new service offerings to support companies, and these offerings are tailored to companies at different levels of maturity, from startups to established multinationals. So if you'd like to explore how we can help with your goals, then please feel free to contact us using the details on this slide. Thank you for listening, and I'll be happy to take any questions you may have. I'm just having a quick look on the comments section. I can't see any questions at the moment. Okay. Well, if you do have any questions, please drop me an email. I'm happy to take the email. Other than that, thank you for listening.
Thank you for watching. Rewatch all of our sessions online. Thank you to our partners.